Good afternoon, everyone, and thank you for joining us on today's webinar on managing sickness and absence within your workforce. During today's session, Alexandra Farmer, Head of Team and Solicitor at Ellis Whittam, and Andrew Eldred, ECA's Director of Employment and Skills, will offer clarity and guidance around managing sickness and absence within your workforce amid the ongoing coronavirus pandemic. Alexandra and Andrew will also answer any questions you may have in a Q&A session that we'll be holding at the end of today's webinar. I will shortly hand over to Alexandra to kick off the presentation, but before I do that, I'd just like to remind you that you can use the questions box on your screen at any time during today's presentation, and our panel will then answer as many as we can at the end of the webinar. Lastly from me, today's session will be recorded, and a full replay of today's webinar will be available on ECA's YouTube channel, and that's at youtube.com/ECA Live. And be sure to also check out our wide range of videos and previous webinar replays on there as well, covering a whole load of technical and business topics. And with that said, I hope you enjoy today's session. Over to you, Alexandra.
Thank you very much. So today we are going to devote the whole of the session to sickness and absence management. Of course, at the moment, COVID-19 and COVID-19 related absence is a huge concern for everyone, but really that's just one reason for absence. And in many ways, it falls to be dealt with in exactly the same way as other absences. So today I'm going to talk through absence procedures, managing short-term absence, returns to work, some common problem areas, disability discrimination, medical capability, and finally unfair dismissal. Next slide, please. So if we start with the right to sick leave, and surprisingly, there isn't actually any specific statutory right to take time off work for that reason. However, most employees have got it written into their contracts, and even if they don't, they'll certainly have an implied term through custom and practice. While there isn't an express statutory right to sick leave, there is an express statutory right to statutory sick pay, SSP, subject to certain conditions. SSP is paid at a specific rate, and that's currently £95.85 a week, and it's paid for up to 28 weeks. I've set out the eligibility criteria on the slide. In summary, you've got a person's got to be classed as an employee and have done some work for their employer. They've got to earn an average of at least £120 per week, and they've got to be ill, self-isolating or shielding for at least 4 days in a row, and that includes non-working days. There are some specific deemed incapable provisions, particularly relevant to COVID-19, and I will come on to those shortly. In some cases, contracts provide an entitlement to more generous occupational or company sick pay, so remember to keep an eye out for that. If you're a JIB member, then there's a formal sick pay scheme that I've set out on the slide. The sums are payable in addition to statutory sick pay and subject to tax and NI in the normal way. There's a 2-week waiting period before sickness benefits paid. Where sickness benefits been paid and a second period of sickness occurs within 13 weeks of return to work, that can be counted as a continuation of illness, so you're not going to have any further waiting days. Next slide, please. So now I'm going to look at sickness absence procedures. Section 1 of the Employment Rights Act 1996 requires employers to provide details of any terms and conditions relating to incapacity for work due to sickness or injury, including any provisions for sick pay. The information can be contained either in a written statement for particulars, i.e. a contract, and that's where it will be in most cases, or the statement can refer to a provision of some other document which is reasonably accessible to the employee, such as, say, a staff handbook. Employers are able to deal with employees who are absent due to sickness, whether that's for long-term absences or persistent short-term absenteeism. Steps can also be taken to manage absence where it's linked to underlying medical conditions, although additional steps may be required, and I'll discuss that further later. Whilst you might not already have a sickness absence policy in place, they are really actually important. Having an effective policy in place and then following it is going to help you deal with absences consistently and effectively, as well as put employees on notice as to the standards of attendance and reporting that you expect from them. That's then going to help you to reduce your legal risk. Therefore, I'd advise that you do have a handbook that has an absence policy in it that sets out how an employee should report sickness absence, what evidence of incapacity you want from them, what their right is to statutory sick pay and/or any company sick pay, what your return to work arrangements are, including return to work interviews, any guidance on medical evidence and/or examinations that you may refer employees for, and processes for managing long-term sickness and persistent absence. And what I'd expect to see is going to be a different policy for each, because managing long-term sickness is very different to managing short-term persistent absences. It's really important that you do have a policy on how you're going to deal with short-term absence, and in particular what you're going to do when people hit a certain absence level. Exactly how you monitor and track it is completely up to you as an individual employer, but if a certain number of absences mean that employees may be subject to a warning, then set those out in a policy so that everyone knows where they stand. One common way to measure absence is the Bradford factor. You may have heard of that. It's based on a theory that short, frequent and unplanned absences are more disruptive to your business than longer absences, and so they attract a higher score. It's based on a frequency and length of their absence during a defined period that's normally 52 weeks. The score is arrived at by squaring the number of instances of absence and multiplying the number of days. And the weighting means, if I can give you an example, that someone who's had 3 periods of absence in 2 days each is going to score higher than someone who's just had 1 period of 6 days off, even though the time out of work's been the same. It's fine to use the Bradford factor, but again, I'd advise that you set out the trigger points within your policy. However you manage and measure your absence levels, either with standard triggers or Bradford factor, you do need to keep in mind disability-related absences. Taking all of that into account without considering adjustments could be discriminatory, and I'll go on to that further later. Employers need to ensure that they've got appropriate policies and procedures for dealing with time off for other reasons, such as sickness, and that needs to be in the handbook too. So those types of policies would be time off for dependents, time to attend medical appointments, and other flexible arrangements. Of course, having procedures in place is only part of the story, and you still need to ensure that you monitor and track absence. It's particularly important that you and your managers have got an accurate picture of the level and patterns of sickness absence across the business, so that any patterns can be identified, and really importantly, so that they can be monitored and enforced consistently. As well as knowing what to count, it's also important to know what to discard. Absences related to disability, pregnancy, and in some cases workplace injuries may need to be discounted altogether or treated differently for your monitoring process. So it needs to be capable of distinguishing between the different sorts of absences. Next slide, please. So if someone's off, the first time you're going to know about it is when they contact you to report the sickness. Your policy should set out what's required, and whilst the logistics are completely up to you, I would strongly advise that you recommend that employees are required to call in and speak to a manager. Research shows that this simple requirement can discourage a practice of pulling a sickie, given that they actually have to speak to someone, rather than, say, text you or send you an email. From a practical perspective, managers need to be aware of the procedural and legal issues which might affect the way in which they deal with an employee reported in sick. Ignoring them is likely to create an increased risk, both from a legal and an employee relations perspective. Therefore, you may want to actually train someone if they're going to be responsible for getting the contact from employees when they're off sick. They need to understand that they need to deal with employees sympathetically and to question them appropriately so that they've got sufficient information to recognise any issues that may require a follow-up. In most situations, it's absolutely fine and recommended to ask an employee for the reason for their absence and the likely date for their return. This information is going to help you to determine the likely impact of the absence. For example, are you going to need to consider getting a temp in, as well as to assess whether you need to gather any other information or put any supportive measures in place, or potentially even seek medical evidence. Equally, a manager should consider whether the absence may have been triggered by an accident at work that may need further investigation. Remember that when an employee calls in sick, it's unlikely they'll have a copy of the sickness policy to hand, so do remind them of their responsibilities. For example, quite commonly, a policy will require an employee to call in on every day of absence whilst they're self-certifying. So if that's what your policy says, remind the employee of that and any other important information. Now, when it comes to evidence of incapacity for work, there's normally two forms of that. One is a self-certification form, and an employee can do that for absences up to 7 calendar days or less. It's up to you. You can either use as a HMRC form, SC2, or you can use a form of your own choosing. For longer absences, you'd then get a doctor's certificate. They're officially called Statement for Fitness for Work, but in short, we call them fit notes, or historically there were sick notes or sick lines. In theory, you're able to decide what evidence you require from employees and at what stage, but you need to make sure you're not being unreasonable. I've never come across a GP who'll provide a fit note for an absence for less than 7 days, and you certainly can't insist on that for the purposes of paying statutory sick pay. After that time, you're permitted to ask for evidence of incapacity for paying statutory sick pay. However, you can't withhold it for late receipt of medical evidence, only for late notification of sickness. So say you've got someone off on long-term sick, they call you up when the sick note runs out and says, I'm still ill, I'm going to get an updated fit note to you shortly. You can't withhold statutory sick pay on those grounds until the updated note is received. Now, keeping in contact with an employee is always a bit of a balancing act. While someone's on sick leave, it is important to maintain appropriate contact, especially with those on long-term sick. The amount of contact's effectively going to depend on their job and the size and culture of your business. And as I say, it's a balance between demonstrating concern and offering support, whilst having enough distance in place so the employee doesn't feel pressured and ultimately they can recuperate and get back to work. Contact could, for example, be limited to a regular telephone update once a fortnight, but just avoid wherever you can any overbearing or intrusive contact. It's good to always agree, I'll call you again in a week or two. If an employee is off for a prolonged period, it will, depending on the nature of their illness, usually be appropriate to send them newsletters and invites to other major events like Christmas parties, if anyone remembers what they are. It wouldn't be advisable to stop all contact for long periods, especially if there are time-sensitive issues that need to be resolved, such as maybe a redundancy consultation. In those cases, decide whether the employee is well enough to discuss them, and if in doubt, provide them with relevant information in writing in the first instance. When you're following any procedure in relation to absence, and to be fair, most of your employment procedures in the workplace, it's really important to ensure that you've got accurate and legible records of all meetings and correspondence sent. If you end up dismissing an employee who's been on long-term sick leave and the employee subsequently brings a tribunal claim for unfair dismissal, one of the key issues to be determined will be whether or not you as the employer acted reasonably in the circumstances, and written records will usually be vital to proving this. Managers need to retain file notes of telephone conversations with absent employees, as well as records of telephone messages left. Ideally, telephone conversations and messages should be followed up with letters summarising the steps taken to contact the employee and any action plans agreed. And the same would be said if you are using text message, WhatsApp. If you're using those sorts of means, keep your records safe. Now, being on sick leave doesn't give an employee carte blanche to do whatever they please while they're off. But employers do often get very worked up if they learn that employees are out and about at times that they'd normally be working. However, what I always advise is you've got to try and remember that the employees have been signed off as unfit for work, not unfit to live. So someone with stress, who's off with stress, they actually could get a lot of benefit from getting out of the house, visiting shops, or a relative, when that's permitted, of course. It isn't necessarily a stick to beat them with. However, if you've got an employee who's off sick, say with a broken leg or a bad back, and they're spotted playing football at the local park, then that might be an entirely different matter. As ever, it's important not to prejudge and conduct a reasonable investigation before taking action against an employee that you think may be swinging the lead. Entitlement to sick pay during sickness absence is governed by the contract or the statutory sick pay, so it's relatively straightforward, and I covered that earlier. However, the position is less clear in relation to the continued provision of other benefits such as a company car, a company van, a laptop, phone, etc. Ideally, you need to have an express contractual provision which sets out the extent to which the entitlement to benefits will continue through sickness. Benefits such as permanent health insurance and private medical insurance should continue during sickness absence, even if there's an express contractual entitlement to end other benefits. Otherwise, the purpose of providing those benefits, particularly things like permanent health insurance, would be completely pointless. Don't forget, if the employee is absent due to a disability, then the employer should consider whether the removal of the benefit amounts to disability discrimination. And as I say, I'll cover more on that later. Can I have the next slide, please? So what I've spoken about so far are the rules and recommendations that apply generally and at all times on absence procedures and process. So now I'm going to turn to issues that relate solely to absence due to COVID-19. In normal circumstances and for non-COVID related absence, there's a 3-day waiting period to be applied before statutory sick pay starts to be payable. That's the case for normal absence, but for sickness related to COVID-19, the requirement for waiting days has been scrapped, and so SSP can be payable from day 1 of absence. The statutory sick pay rebate scheme has now gone live, but it's only for employers with less than 250 employees. If you've paid statutory sick pay to any employee who's been off sick with COVID-19 or anyone who's self-isolated, you can claim back statutory sick pay for the first 14 days of absence. That applies to any absence since 13th of March last year and can be done via an online HMRC portal. Please note, however, that you can only make one 14-day claim per employee. In addition to the traditional fit note, which is obviously really difficult to get currently for all manner of reasons, employees can instead rely on an electronic isolation note as proof of incapacity. And in my experience, that's certainly what I'm seeing coming through. In terms of self-isolation, there are 5 general circumstances under which one of your workers should self-isolate and be in receipt of statutory sick pay. I've put them on the slide, but they are if they've tested positive for coronavirus, if they have coronavirus symptoms and are waiting for the test results, if they have a member of the same household or are in a bubble with someone who has symptoms or is tested positive for coronavirus, anyone who's been in close recent contact with someone who's tested positive and received a notification to self-isolate from NHS Test and Trace. Whilst I'm on that, it's worth noting that the NHS guidance states that if you think you've been in contact with someone who has coronavirus, but you don't have symptoms and you've not been told to self-isolate, then you just continue following social distancing advice. And the 5th one, finally, is those that have been advised to self-isolate at home in the run-up to a hospital admission. The self-isolation period has recently been updated again, I'm sure you saw in the news. So now the base self-isolation period is 10 days. Some people may need to self-isolate for longer if they get symptoms while self-isolating or if the symptoms don't go away. In England, to specifically note, if an employer knows that a worker has tested positive or lives with someone who has tested positive, it's now responsible for stopping that worker from working unless they can work from home, and an employer who fails to do so will face a fine starting at £1,000. Don't forget that, health permitting, an employer in any of these situations listed could work from home if well enough and if that's feasible, although I appreciate this is going to be really unlikely in your industry. However, if they can't, then as a minimum, they're going to qualify for statutory sick pay from day 1 of absence, or company sick pay, depending on the rules of the contractual scheme and how it defines sickness and incapacity. The final point on the slide there is quarantine. Probably going to see less of this now as we've gone into further sort of rules from the government, but the rules around quarantine are a bit of a mess and they're liable to change at really short notice, as we've seen consistently since they were introduced. People who are required to quarantine are only allowed out in really limited circumstances, and in fact the quarantine requirements are much more onerous than the original lockdown we all experienced in March last year. You're not allowed out to exercise or go to the shops, and you can only leave the house for really limited circumstances such as a medical emergency. Again, if they can work from home and that's feasible, that's fine, but any time quarantined would not qualify for sickness absence, and it has to be then unpaid leave or you could agree to a period of annual leave with affected individuals. Next slide, please. So in the current crisis, there are a number of sorts of employees who are not currently at work but fall outside of the statutory sick pay regulations that I've just gone through, and I wanted to discuss those with you too. Firstly, there'll be those who are living with someone who's shielding and may be reluctant to attend work due to concerns about catching the coronavirus and passing it on to the family member who's of a higher risk. If they're not willing to attend work, then this wouldn't count as sickness absence and they don't qualify for statutory sick pay. If feasible, they can work from home, otherwise they'd be granted a period of unpaid leave, or you could approve holidays. It's much the same for those over 70s, those with underlying medical conditions who've been advised to practice stringent social distancing, or people having to stay at home to look after dependents. None of those people are off sick, so they shouldn't be in receipt of statutory sick pay. They could remain off, but if you're intending to call them back and they don't want to return, just take advice about your options, as there could be potential discrimination issues at play. And the final one is pregnant employees, because they're different and they do have additional protections. Again, just to reiterate, if an employee can't attend work during the coronavirus crisis because they're pregnant, that's not going to count as sick leave like the others above. Where they can't attend work due to a health and safety concern, for example, the work environment is unsafe due to COVID-19, they may be entitled to full paid leave, but again, it's important to take advice. Next slide, please. So we're going to now cover shielding and clinically extremely vulnerable employees. Shielding was on and off during 2020. It was announced on 4th of January this year that England and Scotland are going to go into a new lockdown that we've all been in since 5th of January. And during that period, individuals who are deemed clinically extremely vulnerable are being advised not to attend work. Wales is currently subject to slightly different restrictions. However, guidance issued by the Welsh Government late last year states that clinically extremely vulnerable individuals shouldn't attend the workplace, and similar provisions apply in Northern Ireland. Shielding employees may be eligible for statutory sick pay or employment support allowance. Alternatively, and used in most situations where it's available, you could furlough your clinically extremely vulnerable employee under the Coronavirus Job Retention Scheme, which has now been extended until the end of April 2021. If shielding causes or has caused a prolonged period of sickness absence, then you could consider whether or not it's appropriate to look at terminating employment on grounds of medical capability. And I'll discuss the process around that a little later on. Next slide, please. Now let's consider returns to work. The first thing to do upon a return to work after sickness is normally a return to work interview. I can't stress how important they are. It's up to you whether you do them after every absence, but I do generally recommend that. It comes back to the point I made earlier about the importance of a paper trail. The interviews can be really informal, a little chat, and it doesn't need to last any more than a few minutes. That's absolutely fine. Alternatively, you can have a return to work form that could be completed and it's then checked and signed off by a manager. Investigations into the reasons for the employee's absence should always be handled sensitively, and remember to treat all employees consistently. The nature and perhaps tone of the return to work interview will likely vary depending on whether you're dealing with someone who's having frequent short-term absences or they've just returned from a longer period of sickness. For employees usually when the reason for absence has not been as serious as enough to warrant the length of absence taken, you might find that return to work interviews can be a disincentive to take sickness leave. If an employee realises that on their return they're going to be monitored and they're going to be potentially embarrassed to take that period of leave or take as long as they did in the future. Where an employee is regularly taking periods of short-term absence, interviews can also be a good opportunity for you to raise any concerns you've got with them and to explore as part of almost an investigation whether there's any underlying reasons for the employee's absence. That could be related to the health or skill set. Now, where you've got employees who have been seriously ill and absent from work for longer periods, you tend to find that a return to work interview before the proposed return date will help you. That'll help you to establish the fitness for return and how to help them in reintroducing them to the workplace. Managers and employees can work together to identify any adjustments that they may need to make the return easier. Where an employee's got ongoing health issues, it can also be helpful to get all the parties to meet together. And that, when I say together, that can be done remotely on the telephone or a video call to plan a return to work schedule. You often see things like phased returns. Managing the return to work programme sensitively is going to be key to dealing with long-term absences successfully. Employees who've been off for long periods may have recurrent illnesses, which may mean that a return to work for a period and then they're going to suffer a relapse. Knowing when to seek further medical advice is going to be important, as we'll meet with the employee regularly on their return in order to be able to monitor their progress and identify any further adjustments required. Managers should make sure that employees are given achievable goals and that these goals are regularly reviewed in supervision meetings. Now, sometimes you may get an employee and they provide you with a fit note and the GP has stated that they may be fit for work. If that's ticked, it's usually accompanied by suggestions from the GP about ways to facilitate an early return. That really, if you receive that, should prompt a discussion between you and your employee about ways that this could be accommodated. Even if you can make the adjustments suggested by the GP, allowing an employee back into the workplace when they may be fit presents some problems, not least of which that they may inadvertently be putting the employee or other people at risk, or possibly invalidating your employer's liability insurance. So please take advice where possible. Some employees will want to return before their fit notes run out. In the first instance, check with your employer's liability provider if an individual would be allowed back in these circumstances, and if not, simply just don't permit them to return. If there's no problems with the insurance, then it may be appropriate for you to ask for medical advice and undertake a risk assessment before agreeing their return to the workplace. One thing I'd just like to say, though, is that there is no such thing as a fit for work note. The GP will not note them sick unless it's within a full medical report. If the employee is unwilling or unable to provide evidence that they're sufficiently recovered, then you aren't obliged to allow them to return to work for the period of that outstanding fit note. It's as simple as that. Whether or not the employee is going to be entitled to be paid in these situations is going to depend on the circumstances. An employee is only entitled to be paid if they are ready, willing, and able to perform work. If they're signed off as sick, then it seems unlikely that they're going to meet that definition. But again, that's very fact specific, so please do take advice. Adjustments are probably going to be really useful in getting an employee back to work and up to speed following long-term sickness absence or any absence due to injury or a recurring illness or disability. Making adjustments is going to go some way towards discharging your duties under the Equality Act to make reasonable adjustments for a disabled employee, and it'll also help to show that you as the employer have behaved reasonably in relation to any subsequent dismissal if the return to work doesn't work out and you end up terminating the employment of that employee. There's many different examples of adjustments that may facilitate a return to work or otherwise assist an employee on sick leave, such as phased returns, varying start and finish times, relocation or amendment of duties, or the purchase of additional equipment. And sometimes it's just a case of additional supervision and support. It's a good idea to agree with the affected employee that any adjustments are going to operate for a trial period, following in which you should meet to review their effectiveness and discuss any changes that are needed. How much you pay the employee should how much the employee should receive for pay while they're not performing their full duties and full contractual hours is down to agreement between the parties. It's common to agree a prorated rate of pay for the work actually done. However, if they're working their hours and just doing less duties, it's very rare to see any reduction in pay unless it's someone having to pass over, for example, supervisory duties in the meantime. It's unlikely that an employer is going to have a contractual duty to pay full pay for partial performance of a contract. It also seems unlikely that this is ever going to be required as a reasonable adjustment in disability cases. Just one final point. A day on which work is done, even half a day, isn't going to count as a day of incapacity for statutory sick pay purposes. So statutory sick pay isn't going to be available to top up the employee's pay on those days. And in reality, it's very rare to see statutory sick pay available in phased returns due to the waiting days that are required under that scheme. Can I have the next slide, please? Now we're going to move on and look at some problem areas. The first one is pregnancy-related illness. Pregnant employees have a protected period, and that lasts from conception until the end of the statutory maternity leave. Dismissing an employee or subjecting them to any detriment as a result of the pregnancy or a maternity-related illness occurring during this period is going to be unlawful. If you've got a policy of trigger points, like we talked about earlier, and a procedure that may lead to a dismissal once an employee reaches a certain level of sickness absence, you can't take any account of pregnancy-related illnesses when considering those triggers, just discount them all. Towards the end of the pregnancy, any pregnancy-related absence in the last 4 weeks before the expected week of childbirth will automatically trigger the start of statutory maternity leave, so that's important to remember. With holidays and sickness absence, the laws relating to this have been subject to an extraordinary amount of litigation over the past few years, some of which I'm sure you've seen in the press. I'm not going to bore you with all of it, but there are 2 big takeaways to note. Firstly, an employee on long-term sick absence continues to accrue all annual leave for the entire time that they're off, because the employment is continuing. Further, if they wish, they can nominate periods that they would otherwise be off sick as holidays and get full pay for that time off, as opposed to statutory sick pay or nothing if that's actually been exhausted and run out by then. Secondly, an employee who falls ill whilst on holiday may then count that as sick leave instead of meaning that they get that holiday later in the year. All I would say about that, because that can sound quite shocking, is that you'd very much expect they must report the absence at the time it's occurring. They can't come back from holiday and say, I actually was ill through that, I want my time back. It's quite strict in the rules. So what should happen with elective or cosmetic surgery? Should that sort of absence be treated as sickness, or should you ask the employee to take annual leave? An employee's always got the option of choosing to take holiday rather than sick leave. And many do for finance reasons. And in the absence of any specific legislation or case law, this is going to remain a matter for your discretion and best dealt with in a relevant policy. A key consideration is going to be to establish whether the surgery or procedure is purely elective or cosmetic rather than actually for medical purposes. In order to ascertain the true position, you may need to investigate that matter further and obtain medical evidence. Now, notice pay for sick employees is notoriously tricky, but there is one basic point to remember. If you've got an employee who is only entitled to statutory notice and is off sick during the notice period, then they're going to be entitled to full pay during that notice period, even if statutory sick pay has been exhausted. That is not the case if they're going to be entitled to at least 1 week's notice more than statutory minimum. In that case, it would only be statutory sick pay if they're off during that period, or no statutory sick pay if that's already been exhausted, i.e. then unpaid. Next slide, please. So moving now to look at disability discrimination. An individual who's been absent from work by reason of illness could well be protected by disability discrimination law. That's under the Equality Act 2010. So why does it matter if your sick employee is disabled? Well, there's no minimum qualifying period for discrimination claims, and there's no upper limit on compensation. So you have to ensure that you're complying with the relevant requirements of the Equality Act when dealing with disabled employees, no matter how long they've been employed. So when is a sick person going to be considered disabled? A person is disabled for discrimination law purposes if they have physical or mental impairment and the impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. The definition is broken down into 4 questions that need to be answered. I've put those on the slide. If the answer to all 4 of the questions is yes, then the employee will be disabled. It's worth noting that there are a limited number of deemed disabilities, such as blindness, cancer, HIV, and MS. In some cases, it may be obvious whether the employee is disabled, but in other cases, it may be necessary or prudent to get a medical report to find out. As you can see, the definition is pretty wide, and almost anything can constitute a disability if the impact on the individual is serious enough. In terms of a report, that can be either from a GP or from occupational health. GP reports tend to be cheaper, but they won't often give much consideration or advice on adjustments that could be made, so it's worth paying the extra sometimes. Overall, though, it's better to be safe than sorry, so in borderline cases, proceed on the basis that an assumption that the employee is disabled. One point on shielding there. Given the sort of people who've been advised to shield, it's likely that they're going to be suffering with some serious long-term medical conditions. It also seems pretty likely that those conditions are going to have a substantial impact on their ability to carry out normal day-to-day activities. You can get a medical report to check, but it's probably safe to assume that they're going to be classed as disabled for discrimination law purposes. Next slide, please. There are 6 different types of disability discrimination, but I'm just going to concentrate on 3 for this session. The first one is reasonable adjustments. Where you've got a provision, criterion, or practice applied by an employer or any physical feature of an employer's premises which places a disabled employee at a substantial disadvantage in comparison with persons who aren't disabled, the employer must take reasonable steps to avoid that disadvantage. In theory, the scope of possible reasonable adjustments is almost limitless, but we've discussed some common ones already, and they're changing hours, changing job roles and duties, obtaining extra equipment, amending your trigger points for absence management, and so on. The key is that the adjustment must be reasonable, and this is going to depend on the exact circumstances for each case. Do keep this in mind though. Dismissing someone who's been off long-term sick or issuing warnings for disability-related absence can both be discriminatory, so please do take extra care in these cases and take advice. The next category is discrimination arising from disability. That happens when an employee is treated unfavourably because of something arising out of their disability, unless that treatment's a proportionate means of achieving a legitimate aim. And the final one there is indirect discrimination. That's applying a provision, criterion, or practice that puts the employee and other persons with that disability at a particular disadvantage, unless that's a proportionate means of achieving a legitimate aim. In both of those 2 cases, any potential disadvantage can be permitted if it's a proportionate means of achieving a legitimate aim, and it's probably easier for me to explain that with an example. In the case of Cunningham and Financial Conduct Authority, there was a lawyer who had a chronic kidney disease. He was successful in his claim for discrimination arising from disability when he was given a poor appraisal, a scoring of below standard, and no pay rise following a drop in his high usual work standards and a lengthy period of absence from work. He suffered extreme fatigue as a consequence of his disability, which in turn affected his concentration and the quality of his work. The FCA did have a legitimate aim, that being the effective management of the employee's pay and performance, but their failure to make allowances for the effects of his disability meant that it hadn't adopted a proportionate means of achieving that aim. This is an absolute minefield, especially when dealing with discrimination arising from a disability. We see a number of cases that, with what, on the face of it, appear to be really strange outcomes in favour of employees, where employers have ploughed ahead with discipline or performance management without considering the effect of a disability on that. As ever, please do take advice if you're in this situation. Next slide, please. So looking now at medical capability and unfair dismissal. The process and indeed the reason for terminating employment in these types of cases will depend on whether the problem is persistent short-term absence or a prolonged period of sick leave. Persistent short-term absence is perhaps the easiest of the 2 to deal with, provided the reason for the absence isn't disability-related. If it is, we're in the realms of reasonable adjustments. However, if the reasons for the absences vary or they're not particularly serious, this is simply going to be a matter of following your absence procedure and convening meetings as and when the trigger points are hit. It's really similar to a disciplinary procedure. Please note that it's never going to be fair to dismiss someone with over 2 years' service for persistent poor attendance without going through the full range of warnings first. Any warning should be issued following a fair procedure, and should be accompanied by a timescale and suggestions for improvement, together with details of the action that the employer is going to take if there's no improvement within the specified timescales. You effectively need to set out a trigger for the next stage of when that may be hit. In short-term absence cases where the reasons for sickness vary and aren't serious, it's hardly ever going to be necessary to obtain a medical report. If there's a pattern to absence or an underlying condition, then a report may be needed, particularly to look at adjustments. One common question that's arisen lately is the extent to which COVID-19 related absences can be taken into account under a sickness absence procedure. On the face of it, you can take it into account because, as with any short-term absence, it can be incredibly disruptive on the business. As a result, if trigger points are being hit, as a result of the constant need to self-isolate, then it may be reasonable to consider issuing warnings under your proceedings. However, don't be too hasty and remember to act reasonably in the circumstances. We're living in an unprecedented and extraordinary time. In recent history, individuals have never been required to miss work because they might be ill, which is effectively what's happening now. If the nature of someone's job puts them at a higher risk of infection or potential infection, would it be really reasonable to take action against them for that? Possibly not. And the difficulty that we're facing is that at this point, we have no idea how a tribunal is going to deal with this sort of issue, and that's unlikely going to come out for another year or two, given the delays in the tribunal system at the moment. Next slide, please. Moving on to unfair dismissal and long-term sickness. When an employee has been off work for a significant length of time, or the prognosis is that they're going to be absent for a long period, you're going to need to consider that situation carefully. The most obvious option is going to be potential dismissal on the grounds of capability, but there might be other options that need to be explored, not least to mitigate against the possibility of unfair dismissal and Disability Discrimination Act claims. You aren't expected to hold a job open forever. No, that's the positive news for an employer. However, a common question I get is how long does someone need to be off before a dismissal is an option? The answer, I'm afraid, is it completely depends. There's no prescribed time limit set out in law. Certainly, you can't be too hasty in these situations. Unless you've got early medical evidence, and it's very clear that a return to work isn't going to be possible for many months or even many years, which we do get from time to time, my own rule of thumb is going to be that a minimum of 6 months absence is going to be required before a dismissal is a reasonable potential outcome. Medical evidence is going to be absolutely crucial. You can get a report from the employee's GP or from occupational health, but the report needs to address key factors such as the nature of the illness, whether it amounts to a disability, the prognosis, and whether any adjustments can be made to facilitate a return to work. Once in receipt of a report, you're going to need to act in accordance with any recommendations that report sets out. However, often with employees on long-term sick leave, the prognosis is going to be unclear, and it may not be possible to give the return to work date. If no adjustments can be made, and the next stage is going to be to invite the employee to a meeting to discuss the possible termination of their employment. In terms of a process, the employee should be invited to a meeting in writing, be warned that one of the possible outcomes may be the termination of employment. They'll also be entitled to be accompanied. The invite letter needs to enclose all of the relevant documentation that you're going to be relying on, importantly, the medical report. Be considerate of the condition, and sometimes it's going to be appropriate to offer to hold the meeting remotely if necessary. I have also had situations where even that's not possible and you end up doing a meeting in writing, going back and forth, or having written submissions in advance. At the meeting, you're going to be discussing the absence of the history of the absence, the latest medical evidence in detail with the employee. Try to find out if they agree with the findings of the doctor or the occupational health specialist. Allow them to give their version of events and outline any mitigating circumstances. At the end, sum up what's been discussed, confirm to them that you're going to consider everything, and then you would give an outcome in writing. You wouldn't make an immediate decision. If the decision is to dismiss, always offer the chance of appeal. I've mentioned again on the slide disability discrimination because it really does pervade this sort of process. An employee's been off sick for a long time, my apologies, is highly likely going to be disabled, so don't forget to bottom out the issue of reasonable adjustments and determine whether any dismissal can be objectively justified before making a final decision. I'll end with two minor but important points. Firstly, if the employee has the benefit of permanent health insurance, then it's likely you're going to need to leave them employed and in receipt of that insurance rather than dismissing them. It's also a similar story with ill health early retirement. If you've got an employee that's a member of a pension scheme, then you should bottom out whether or not they're entitled to any ill health early retirement before looking at a capability dismissal. Next slide, please. So before I conclude, I'd just like to take this opportunity to remind you of the guidance and additional Ellis Whittam online resources that are available to you. On the slide, you can see the link to the ECA Employee Relations webpage. That also includes information and links to the ECA's Employee Relations Advisory Services operating hours, phone number and email address. The ECA Guidance Notes can be found through the second link, and the page with links to the Ellis Whittam online resources can be found through the third link. I've also put up there some details of how to access Ellis Whittam's COVID-19 Advice Hub. That's a really relevant resource, constantly updated at the moment with employment law and health and safety guidance and templates dealing with risk assessments, furlough, staff absence, etc. Also accessed through that COVID-19 hub is our Back to Business hub. That's got a number of guidance notes and template letters on really relevant employment law issues. There's detailed guidance about absence management on there too. It's a really great resource, so please feel free to sign up for it if you wish. Next slide, please. Thank you.
Okay, I think that's me now. Thanks very much to Alexandra for that excellent presentation, giving us plenty to chew on. I'm just going to keep you for a minute or so, pending any questions. And some of what I've got to say actually reiterates what Alexandra had to say. Obviously, there is, as ECA members, you have access to the advice helpline. And one of the benefits of the tie-up we've had with Ellis Whittam for the last few months is that now operates to longer opening hours, 7 a.m. to 11 p.m. either by phone or by email, weekdays and weekends. Alexandra's already referred to the various employment guides and templates that you can find on the website. Something she didn't mention, but something that you might be interested in knowing about is that through your ECA membership, you also get access to some additional Ellis Whittam services at a discounted rate. So if you like longer term, more ambitious things like HR consultancy, tribunal representation and so on, those are all available. If you're interested in any of that, then contact us at ECA and we can discuss that with you and potentially pass you on. In terms of other updates, again, a reminder, as well as the Ellis Whittam COVID webpage, which obviously is mainly focused on employment matters. The ECA Business Recovery webpage includes a lot of employment-related stuff, particularly cross-referencing some of the sort of industry-relevant, JIB-relevant aspects of that, plus, of course, a lot of other stuff around health and safety, commercial, and so on. And finally, and I've included this because we often get asked this question even when we're not presenting specifically on the JIB. But the present situation for those of you who are JIB members with regard to JIB terms and conditions is, as you know, we're now in a new year, 2021. We've effectively rolled over from 2020 all the existing rates, benefits and allowances, with the sole exception of a small increase to the lodge. And we're currently awaiting a union claim in relation to 2022, which, as you know, these things get negotiated a year in advance, but we have not yet had a claim for 2022 from Unite. And on my final comment on the JIB, before we go over to questions, is the various flexibilities that have existed since March, April time with regard to JIB terms and conditions, most specifically the temporary benefit, the temporary furlough benefit, that continues right until the end of April, as Alexandra says. That's when furlough at the moment carries on to. If you are putting people on furlough, or still have people on furlough from way back, that as a JIB member is available to you as a reduced price benefit. But it still ensures that those employees are covered for the other aspects of the benefit package. So that's it really from me, and I think over to you, Omar, to handle any questions.
Thank you, Andrew, and thank you to Alexandra for that very comprehensive and its insightful presentation. We do have time for a few audience questions. So the vast majority of these questions are for you, Alexandra. So the first one is, when do employees need to have joined the business to be entitled to claim for the SSP rebate?
They just need to have done some work. So it's pretty much going to be a day one right for most people, but they still have to have those average earnings as well.
Okay, thank you. We've got a second question here. If you have an employee who can't work due to having children at home, what are the options? He says we have plenty of work on site, but they can't take their child to site, so would furlough be appropriate in this case?
Yes, that furlough is highly likely going to be appropriate. The coronavirus scheme rules are quite clear that it's to assist where your operations are impacted by coronavirus, but it's also where an employee is unable to work for a reason linked to coronavirus. So at the moment, because a number of schools, secondary schools, primary schools are shut, if it's because of that and they've got, say, younger children who can't be left alone at home, then the furlough scheme would be available to be used in those circumstances.
Okay. Next question. What if we have an employee who has been told by his GP to shield, however, he cannot work from home, but is refusing to shield?
Really good question. Really good question. Actually, this is something that the guidance from us has actually changed a little bit as we've gone into 2021. If we'd have spoken last year, what we were sort of saying is that because the guidance is advisory, it's not mandatory. If an employee wanted to attend work, then you could do a risk assessment, and if that showed it was safe for them to attend, and you checked with your employer's liability and they were happy for them to attend, then we did see some shielding staff attending work. However, as we've gone into the new year, we've also got a more contagious and this strain of coronavirus that's going around. And when I've discussed this at length with my health and safety colleagues, what I'm being told is ultimately that it's never expected that you're going to be able to show on a risk assessment any measures to make it safe for that employee. So our advice at this point is very much, if an employee has been told to shield by NHS, by the GP, then do not allow them to work. And at that point, if they agree to furlough, then they can do that. If they are saying they refuse to take time off and they're refusing, then unfortunately that might then trigger a requirement for you to pay them in full while they're absent. So you could still use furlough with their agreement, but in that situation you need to top up to full pay.
Okay, thank you. I've seen a few questions come in asking about the slides themselves and will they be made available. This whole session has been recorded and will be uploaded to the ECA YouTube channel, and that should be available from tomorrow morning. And also all the links and resources that were mentioned on the slides here this afternoon will be accessible in the video description on YouTube as well. So on to the next question. If a member of staff has been absent with anxiety/stress for say 6 weeks, and this is the first time any such reason has been given for absence, could they be considered to have a disability as it is a relatively new diagnosis, or would it need to be over a longer period for the employer to be at risk of unfair dismissal should they be dismissed for redundancy?
Okay. So it's very fact specific. So the fact that someone has a new condition, the sort of default answer is the hope and expectation is that that's not going to become a disability. It's not going to be long term. However, for something to be considered long term, what we're looking at is that it's lasted or is expected to last for 12 months or more. So with conditions such as, say, anxiety, like you say, the difficulty is that it's not going to be a quick fix. It's not like you can put a cast on it and within 6 weeks that'll be removed and you'll be back to normal with a broken wrist or whatever it may be. So the difficulty is that it's unclear at that point. What we tend to advise is that you'd want to speak to the employee, because you'd want to explore whether there's any history of that. So even if for you it becomes a new issue, you may well uncover there's been a history of anxiety related illnesses in the past, and also discuss, have they spoken to the GP? What's the expectation with treatment, etc. moving on? In terms of you might at that point then depending try and get guidance to go to a medical report from the GP or occupational health before moving on to a dismissal. It certainly wouldn't be safe to immediately just dismiss without exploring those avenues further.
Right. We've got a broader question about furlough in general here. It's more of a two-parter. So how flexible is furlough currently? Is it still day by day if necessary? And is furlough still restricted to employees who've started after 1st of October 2020?
So they had to be on the payroll, I think it's the 30th of October. I have to double check that. I'm pretty positive it's the 30th of October, and you had to have done an RTI submission by that date also. So both of those things to qualify for furlough. They've not changed or extended that given the new lockdown. So anyone who was employed after that date, you're going to be looking at other options such as layoff or short-time working. You do still have the flexibility of the flexible furlough scheme, so the ability to change that working arrangement as suits your business. You can either agree that at the outset, or you can agree that there'll be flexibility based on what you say a week in advance, etc. So that's the good news.
Thanks. We've got a couple more questions here. We've got about 3 minutes left, so a little bit of time. If a member of staff was furloughed prior to contracting COVID-19 and now has long COVID, can they still be furloughed as they are not able to survive financially just on SSP?
The chances are probably going to be yes. The scheme does allow for employees who are off on long-term sick to be furloughed. And obviously the absence here is due to coronavirus. It's not, you would never use the furlough scheme for short-term absences, such as self-isolation. But here, what the reason for the ongoing absence is, to some extent, whether it's COVID or something else, partly irrelevant. I think the big issue would be whether or not your business is also impacted. The risk at the moment is that we don't fully know how HMRC are going to audit any claims as they come through. The guidance does refer to being able to furlough people on long-term sick. However, if your business is not otherwise impacted, so but for the long-term sickness leave, they would otherwise have work to do, it's a little more unclear. What we're suggesting is, with these areas of uncertainty, is that you can contact HMRC. They've got a web chat facility, or I'm also seeing a lot of people contacting them on Twitter, and you can ask them the question. They can give you a bit more guidance on your specific circumstances, and then you'll be able to keep hold of that, print it out, so that you can keep it with your arrangements if they've said yes, you can furlough, so that if it's checked later, you can show that's the basis upon which you took that decision.
Okay, thank you. We're coming up to past. We've got one final question that we'll just squeeze in before we close off the session. If there is an employee on partial furlough, can they change the days they work? I.e., if they currently work Monday, Thursday, Friday, could that be changed to Monday this week, Thursday next week, etc.?
Yes, yeah, you do have flexibility within the flexible furlough scheme. So as long as you've got your arrangement in place, as I said earlier, you can either fix it for certain days, or you can leave it open that you will work flexibly as per the needs of the business. It's then just going to be really important that you're monitoring that and keeping a record of that, so that your claims match based on what's actually been worked and what time has been then furloughed and off.
Great, thank you. So we'll conclude today's webinar there. Thank you once again to our panelists, to Alexandra and Andrew, and thank you very much to the audience for joining us this afternoon. For many more resources about employment issues relating to COVID, please visit eca.co.uk/business/COVID-19. recovery. We've got plenty of resources there, updated frequently as well. And thank you once again to everyone, and have a lovely rest of your day.